Hello everyone, I'm Aratrika Bhaumik and I welcome you all to another episode of Courts Today on LiveLaw, where we update you about all the important legal developments that took place across the country today. We will begin with developments from the Supreme Court of India and then move on to High Courts and other lower courts. If you like our content, please do not forget to like and subscribe to our YouTube channel. Let's begin. A constitution bench of the Supreme Court has by a 3:2 majority upheld the validity of the 103rd constitutional amendment, which introduced 10% reservation for economically weaker sections in education and public employment, popularly known as the EWS Quota. While Justices Dinesh Maheshwari, Belam Trivedi and J.B. Pardiwala upheld the 103rd constitutional amendment, Justice S. Ravinder Bhat wrote a dissenting judgment to strike it down. Chief Justice of India Umesh Lalit concurred with the minority view of Justice Bhat. We have made a detailed video on this landmark judgment, the link to which has been given in the description box below. Please do check it out. In a relief to Chief Minister of Jharkhand Hemant Soren, the Supreme Court of India today held that the public interest litigation petitions filed in the Jharkhand High Court seeking a probe against him for alleged money laundering are not maintainable in nature. The Supreme Court has set aside the order of the High Court which held as maintainable the PILs which sought a probe against Soren for alleged money laundering through shell companies and also for obtaining an alleged mining lease while he was in power. The state and the then Chief Minister moved the Supreme Court after the High Court had accepted sealed cover documents produced by the Enforcement Directorate in these PILs. The Supreme Court of India today issued notice to the Election Commission of India in a plea filed by Samajwadi Party leader and former Uttar Pradesh Minister Muhammad Azam Khan, challenging the press note dated November 5th issued by the Election Commission of India stipulating schedule for declaring by-election to the Rampur Assembly constituency in the state of Uttar Pradesh. Posting the matter for hearing next on 9th November, that is Wednesday, a bench comprising Justices D.Y. Chandrachud and Hima Kohli asked the AAG of the state of Uttar Pradesh, Ms. Garima Prasad, to take instructions in the meantime. A division bench of the Supreme Court of India today dismissed the challenge against a decision of the Allahabad High Court to disqualify Rampur MLA Muhammad Abdullah Azam Khan for not having attained the age of 25 years on the date of the election as prescribed under Article 173 Clause B of the Constitution. In 2019, the Allahabad High Court had struck a major blow to Khan's electoral aspirations when the petitioner one Nawab Kazam Ali Khan moved the court claiming that the young politician from the Samajwadi Party had falsely represented himself to be older for the purpose of contesting the assembly elections. The Supreme Court bench comprising Justices Ajay Rastogi and B.V. Nagaratna dismissed the appeal, with Justice B.V. Nagaratna delivering a separate but concurring judgment. A court in Gujarat's Morbi district on Saturday refused to extend the police remand of 4 accused persons, including 2 managers of the Endeavour company in connection with the October 30th Morbi bridge collapse incident in which at least 140 lives were killed. Earlier on November 1st, 4 accused persons had been sent to police custody till November 5th. Now on Saturday, when the prosecution sought further police remand of the accused persons, the court denied the same and instead sent them to judicial custody. Of the 4 accused persons, 2 are managers of the Endeavour company who were awarded the contract and who were in charge of the affairs for the renovation of the bridge, and the other 2 were given the subcontract for the maintenance of the bridge. In a significant development, the Gujarat High Court today took suo motu cognizance of the Morbi bridge collapse that took place on October 30th and has claimed 134 lives. A High Court bench of Chief Justice Arvind Kumar and Justice Ashutosh J. Shastri today called the disaster where hundreds of citizens had died an untimely death as disheartening and proceeded to take suo motu cognizance of it. The state government has been ordered to file a status report by next Monday. The State Human Rights Commission is to file a separate report as well. The matter is now listed for further hearing on November 14th. We have made a detailed video on this hearing, the link to which has been given in the description box below. The Delhi High Court has held that all the candidates belonging to reserved categories, as notified by a presidential order in any state or union territory, would be entitled to the benefit of reservation in Delhi subordinate services. A High Court division bench of Justice Vibhu Bakru and Justice Amit Mahajan was dealing with a bunch of petitions filed by candidates belonging to the scheduled caste and scheduled tribe categories who had appeared for interview for the post of court attendant or room attendant group C in the High Court, but were subsequently not recommended for appointment for not submitting any proof of being an ordinary resident of Delhi. The Kerala High Court has recently reiterated the settled position while considering custody matters that the court must pass orders ensuring that the child is not totally deprived of the love and affection and company of one of the parents. The division bench comprising Justice Anil K. Narendra and Justice P.G. Ajit Kumar has observed that if the child is denied the opportunity to interact with one of the parents, it certainly will cause snapping of the emotional and psychological bondage. While stating so, the bench took note of the settled position in the case of Yashita Sahu vs. State of Rajasthan, where the Supreme Court had held that the child has a human right to have the love and affection of both the parents. Hearing an appeal challenging a single bench's decision banning the playing of music in all pubs after 10 p.m., the Telangana High Court has said that interim directions passed by the single judge in September will apply only to 10 pubs in the Greater Jubilee Hills areas against which complaints were made by residents. The single bench on September 12th had issued a slew of general directions to the police in Hyderabad, Cyberabad and Rachakonda in petitions filed by a group of locals and the Jubilee Hills Residents Clean and Green Association against the alleged inaction of state authorities in not taking action against pubs in residential areas. A total of 10 pubs of the Jubilee Hills area were arraigned as parties in the cases. Thank you. Keep watching Courts Today on LiveLaw for more such updates. If you like our content, please do support us by liking and subscribing to our YouTube channel. See you tomorrow.